Hi, I'm Cary Coglianese. I'm on the faculty at the University of Pennsylvania Law School, where I teach administrative law, environmental law, and regulatory law and policy. And I'm here today to talk about Chevron and the administrative state. No, that's not Chevron, the oil company, but Chevron, the Supreme Court decision. Actually, it's the most cited Supreme Court decision on administrative law of all time. What I'm going to do today is walk through four basic points. First, I'm going to provide some background on the administrative state. Administrative agencies make up a lot of what the federal government does, and they are creatures of statutes. They are created, empowered, and constrained by statutes. And it turns out that courts often have to come into the picture and solve disputes over the meaning of those statutes. And when those disputes over the meaning of statutes governing administrative agencies comes about, that's when the Chevron decision becomes relevant. So the second thing I'll do is talk about the Chevron decision and the two-step framework that it has articulated. The third thing that I'll do is address the legal justifications for Chevron Deference. And I'll explain what Chevron Deference is once we go through the two-step framework. Finally, I'm going to talk about another Supreme Court decision, a decision known as Meade, which amplified and followed on Chevron and makes clear that the Chevron framework actually has more than just two steps. There are some steps in between step one and step two. So let's get started. Just to orient ourselves, think about the federal government, as we all know, comprising three branches. Article 1 of the Constitution speaks of a legislative branch, Article 2 of an executive branch, Article 3 of a judiciary. And the institutions at the top of each of these branches are well known to the public: Congress, the President, the Supreme Court. But what might be less well known or understood is the work of the hundreds upon hundreds of administrative agencies. Agencies that are formally situated within the executive branch, and the Constitution in Article 2 does speak of departments. And so we have agencies known as the Department of Transportation or the U.S. Department of Agriculture. But we have other agencies, the Occupational Safety and Health Administration, the Securities and Exchange Commission, the Internal Revenue Service, for example. These are performing a great deal of work of government. Now, where do they come from? As I said, Article 2 of the Constitution contemplates departments, but it's really Article 1 in the Necessary and Proper Clause that makes clear that these agencies can be created by Congress through legislation or statutes. Agencies, in other words, are creatures of statutes. They come about because of statutes. They gain powers to regulate due to statutes, and they must follow the terms and operate within the constraints of statutes. But what to do when the statutes are unclear, or there's a dispute over the statute and its meaning? Well, let's take an example. The Clean Air Act. It gives the U.S. Environmental Protection Agency to regulate sources of air pollution. Okay, but what are sources? Are they each individual smokestack? Or is it the overall plant or facility to which those smokestacks are connected? Well, economists have long argued that a more cost-effective approach to environmental protection would be to adopt the plant-wide definition, to think, in other words, about an imaginary bubble that could be placed over an entire factory, and the regulator would impose an emissions limit on everything that came out of that bubble. This is the kind of understanding of the word source that the US EPA adopted in the early 1980s during the Reagan administration. It adopted a bubble policy that accepted the plant-wide definition of source, not the individual smokestack by individual smokestack definition. Environmental groups thought that the individual by individual definition was more environmentally protective, so they went to court and filed a petition for review against the EPA, asking a court to declare that the EPA had violated the Clean Air Act by adopting a definition of source that doesn't fit with the meaning of the Clean Air Act. The case is known as Chevron versus Nrdc, by the way, because Chevron, the oil company, filed to intervene in the case and join, in a sense, on behalf of the EPA because it liked the more flexible definition and wanted to defend that. So the case is known as Chevron versus Nrdc, even though the EPA was at the heart of it. The EPA, incidentally, was headed by Ann Burford Gorsuch at the time, and the court won this case, which is kind of interesting because Ann Burford Gorsuch is the late mother of Justice Neil Gorsuch on the Supreme Court, and Neil Gorsuch is one of the biggest critics of the Chevron case that his mother's EPA won. Go figure. In any event, let's look at this case and try to understand what was involved here. The dispute, remember, was over the meaning of the word source. And I might ask at the outset, what should the court decide? Is a source an individual smokestack? Or could it mean the whole facility that has multiple smokestacks? Well, courts have general principles of statutory interpretation, kind of a formula that they follow to interpret a statute and find out what it means. And that formula or those principles always start out with the text of the statute. And so the Supreme Court in the Chevron case began looking at the statutory text, the text of the Clean Air Act. And the court noticed that there was a definition of the word source in Section 302J, but it wasn't very helpful. Source was defined to mean just a source of air pollutants. Now, there was, in another part of the statute altogether, Section 111A, another definition of source. That meant a building, a structure, facility, kind of similar to what EPA had adopted, but the court said this was a definition that applied to a different part of the Clean Air Act than the part that was relevant to the dispute over the bubble policy that EPA had adopted and was at issue in Chevron. So in the end, the court concluded that the text just really wasn't clear. There was nothing that could be discerned from the text about whether a source should be just an individual smokestack or a whole plant or facility. So the court did what courts will at times do, is looked elsewhere to try to understand what this statute meant. And the elsewhere that courts will turn to often is to legislative history. This refers to the history within Congress that led from the bill being introduced to a law being passed. So the court went looking for committee hearings and committee reports and statements made on the floor of the House or the Senate, sponsor statements. Did any of these materials speak at all to what a source of air pollution means? Well, the court came up empty-handed. Nothing in that whole vast legislative history of congressional deliberations leading up to the passage of the Clean Air Act spoke at all to what a source should mean. So what then? Well, the court then looked to the last possible source of statutory meaning, the purpose of the statute, or the policy that it served. And the court said, well, there's good arguments really on both sides here. The purpose could be, like EPA is saying, let's clean up the air at the lowest cost possible. Or maybe it was the environmentalists, which wanted a definition that they thought was the most stringent. At the end of the day, the text, the intent, and the purpose of the Clean Air Act just didn't say what a source would mean. So what should the court do? Well, this is where the Supreme Court articulated its two-step framework. The first step, the Supreme Court said, for a judge to do when faced with a question about what a statute means in the administrative law context, where there's an agency involved, the first step is to do what the Supreme Court had already done, which is to go through the traditional tools of statutory interpretation to see if the statute is clear. If it is clear, well, obviously, that clear meaning must control, and the courts are obligated to apply that meaning. But what if it is not clear, as in the case of what the word source meant in the Clean Air Act? Well, the Chevron court then said there's a second step. And if the agency has adopted an interpretation of that ambiguous provision, and that agency's interpretation is a reasonable one, then the courts are actually obligated to follow what the agency has said. This is what is known as Chevron Deference, deference that occurs at step 2 of Chevron. Okay, now, this notion of deference should be distinguished from another older notion of deference called Skidmore Deference after a Supreme Court decision in 1944. Skidmore Deference isn't really, in some ways, deference at all. The court in 1944 simply said that an agency's views about what a statute means could be taken to be persuasive by a court. And if a court is persuaded that the agency has the right interpretation, then of course it should follow it. Chevron deference, and this is important to understand to see the significance of Chevron and the challenge in justifying it legally. Chevron deference is binding. A court is obligated to follow what the agency says, as long as the statute's unclear and the agency's interpretation is a reasonable one. It's binding. Not just if you find it persuasive, follow it. You have to follow it. Okay? Now, how could this be legally justified? Especially in light of things like the Supreme Court's decision in Marbury versus Madison, with Justice Marshall's statement that it's emphatically the province of the judiciary to say what the law means. Or how can that be squared with the Administrative Procedure Act, a statute that governs administrative law and administrative agencies? That statute says that it's the responsibility of the court to decide all relevant questions of law and to interpret statutory provisions. Why then does the agency's interpretation not only win, but create an obligation on a court to follow it? Well, in the Chevron case itself, the Supreme Court articulates 3 arguments for deference. The first is based upon expertise. Agencies are more knowledgeable and better equipped to design a statute and implement that statute and figure out what the statute means that will best fulfill the purpose of the statute. Okay. Another argument the court puts forward is that administrative agencies are more politically accountable than courts. Courts are staffed by judges who are appointed for life, whereas agencies are headed by administrators who are appointed by presidents and only serve as long as usually the president's term, and they're also confirmed by the Senate. So they go through a political process. They're much more democratically accountable than Article 3 judges. Whatever you might think about these arguments, they aren't really legal arguments. They're policy arguments. They're institutional arguments. They're arguments about why it makes sense for judges to defer to agencies. Why, it's a good idea, but a good idea isn't a legal argument necessarily. Here, it's the third argument that comes through in the Chevron case that really is the foundation of Chevron deference and widely accepted today as the legal basis for Chevron deference. And what is that? Well, that is that there is a delegation of authority from Congress to the agency to fill in the gaps and to define ambiguous terms. The court makes an argument first based upon an explicit delegation that might be given in a statute. And this is found in many statutes. For example, the Affordable Care Act or Obamacare. That statute specifically, explicitly delegated to the Secretary of Health and Human Services the responsibility to define what constitutes essential health services. The statute said the Secretary shall define what constitutes essential health services for the purposes of what health insurance should cover under the Affordable Care Act. That kind of express delegation is the law. Congress has told the Secretary to determine what essential health services mean, and the courts obviously shouldn't step in and give their own definition of what essential health services means. If they did, they would be acting in contravention of the statute and the clear express delegation to the agency. Sometimes this, according to the Supreme Court, those kind of delegations are not so clear and express, but they are nevertheless implied. It's implicit. And the court said that's what was going on with the Clean Air Act. True, source was never defined in the statute, and true, the statute never expressly said that the EPA administrator shall define the word source. But by giving the EPA responsibility to implement, carry out, administer the Clean Air Act, Congress was effectively delegating to it the authority to determine what ambiguous words means, at least in a reasonable way. And you can find language throughout the Chevron decision that acknowledges this kind of delegation, that statutes give agencies responsibilities, they entrust duties to them, they charge them with obligations, and they delegate. All of this language here is speaking to the conventional understanding of the legal grounding for Chevron deference. It's grounded in a delegation. So with that, let's turn back to Chevron and its framework for a moment and try to think about it in a spatial sense. Think about a line, and there are various points on that line that could represent different meanings of a statute. Step one of Chevron is asking courts to consider whether there is one and only one reasonable understanding of the statute, and if so, then to follow it. Okay, that makes sense. But what then if there are more than one reasonable understandings of a statute. The statute is ambiguous. Then what? Well, given what I've just told you, you might begin to think a lot like law professors and judges think, that means going to step 2. A lot of folks think about Chevron, I think mistakenly, as a bit of in bit of terms much like an infomercial, that Chevron is simple. It clarifies things in just 2 steps, step 1 and step 2. But wait, there's actually more. And more came to be clarified in the decision of the Supreme Court in the case of U.S. versus Meade Corporation. Now, this was a completely different case than the Chevron case, involving a different statute altogether. This was a tariff statute dealing with the taxes and fees that can be imposed upon imports. And the specific language in this case dealt with diaries, notebooks, and address books bound. Anything deemed to fit within that definition, subject to a tariff. And in fact, the Customs Service issued a ruling letter that a product that the Meade Corporation sold, day planners, were subject to a tariff. Now, what's a day planner? Back in the day, before smartphones, this is what a day planner was. And this is how people kept their appointments and kept track of all of their contacts. It was state of the art. And the question in Meade, really, are these day planners diaries, notebooks, and address books bound? So you should ask yourself, as a lawyer or a judge, you ask, does the statute provide a clear single answer? Step 1. Maybe you can imagine some arguments that it was bound. It was in a binder. But maybe you can imagine arguments that it wasn't. It wasn't actually glued. Pages could come out and be put in. That's not bound. Well, if you think that these arguments on both sides have merit, you would be probably with the Supreme Court. And in the Meade case, the court there said the statute wasn't clear. So, if it's not clear, what then? The court said, wait, before you go to step 2, you have to figure out if Congress actually delegated some authority to the agency to construe the meaning of those terms in the statute. And here the court said no, it hadn't, because these ruling letters were just really quite informal letters that could be issued by any customs officer anywhere in the country. This was not the kind of decision that it made sense to think that Congress implied that a customs officer somewhere in the middle of the country would make a decision as to the meaning of this statute that would be binding on an Article III court. No! The only way to imply would be really if there was something in the statute that made sense to imply a delegation. One of those things could be a provision in the statute authorizing the agency to make binding law, say through rulemaking, the process of creating regulations. If the agency had that kind of authority, and if it was using a rulemaking authority to determine the meaning of a statute, then it would make sense to imply a delegation and the court to defer to the agency's understanding. That's what Meade held. That's what Meade held. The key takeaways here about Chevron from the Meade decision, well, there's 2 of them. The first is that getting to step 2 and having an agency prevail based upon Chevron deference, well, that's not something that's automatically granted just upon a showing of ambiguity at step one. No, there are more than just two steps. In fact, rather than a two-step framework, what the Meade decision made clear, although it was also evident on a careful reading of Chevron, is that there's actually multiple steps. Justifying Chevron deference requires first asking step one, is the statute clear? If it is, then it doesn't make sense to imply any deference because the statute has no room for anything but what it means. But if it is not clear, then there's some intermediate question or step that has to be cleared. Did Congress either explicitly or implicitly delegate the clarifying or gap-filling authority to the agency? If that answer is yes, then, and only then, should a court get to step two and ask whether the agency's interpretation is reasonable and be bound by it if it is. But wait, there's still more. One other thing that the Meade decision did is it said that Skidmore deference remains available to courts when Chevron deference does not apply. So it's not as if agencies will automatically lose if they don't get to step two. The courts can still defer to agencies if they're persuaded that they're correct. Ultimately, what the structure of Chevron looks like is not a two-step framework, but what I have called the Chevron staircase, a veritable staircase that starts with step one and then has a host of intermediate steps that have been articulated in Meade and other Supreme Court decisions that must be cleared before a court gets to step two. We won't have time to go into all of these, but suffice it to say that the two-step framework that the court articulated in Chevron is more complicated in reality. It does require clearing some other hurdles, but it also provides a basis for deference at step two, and it may go some distance in addressing those who are concerned about Chevron deference and are critical of it. Thank you very much for your time, and have a great day.